We're getting started a little bit late, so I'm going to keep my introduction pretty short. But I'm thrilled to see so many of you out for the Cultivation Classic. Let's give it up for the Cultivation Classic. Some really amazing people put this event on, so I'm really grateful to them and to them for making this space where we can do something that I've been really excited about doing, which is bringing lawyers together with breeders to talk about legal resources. This is a really important conversation for all of us right now. So my name is Beth Schechter. I am the Executive Director of the Open Cannabis Project. Actually, as many of you might know, we're closing. This is our final public offering. The reasons that we're closing are very long, and I'm happy to talk to you about that at another time. Just part of why, as a bit of housekeeping, we've put together a roundtable event tonight at Botanist Bar at 7 p.m. It's close to here. If you have thoughts and feelings about the Cannabis Project and us closing, have thoughts and ideas about what we should be doing in the future, this is an open invitation and I invite everyone to participate. Today, right now, I'm really excited to bring to the stage some really incredible lawyers. We have Carla Quisenberry from Miller Nash, who is going to be talking about patents and licenses for strains. We have Christy Stankiewicz from Greenspoon Martyr, and she's going to be talking about, I always get Miller Nash and Greenspoon Martyr confused, and I know I really shouldn't, and the lawyers who work with it don't do that. But she's here to talk about interstate commerce, along with Adam Smith, who is right here from the Craft Cannabis Alliance, and congratulations, Adam, on the bill that you put together, just passing the Senate. Big round of applause for Adam. And last but not least, we have Kamran, what is your last name? Arya, and he is going to be talking to us about FDA and hemp. And in terms of lawyers I've spoken with who are up to date on FDA and hemp stuff, he takes the cake, and I'm really thrilled for him to be here to answer a lot of your questions. I'm trying to think if there's anything else we need to know. I think that that's it for now. So with that, I'm going to hand this over to Carla to talk about patents and licenses. Yeah.
So this is going to be a fairly quick discussion about patents. I could talk about patents for the entire 2 hours. You all probably don't want that, but I could. So why patents? I realize that, especially in the cannabis industry, there's a lot of sort of questions and misperceptions about patents in this industry. One reason to have a patent is it's a great defensive tool. Say that you yourself are sued for infringement on a patent. Okay. Thank you. If you have a patent that you can also then assert against your accuser, then you can then negotiate a cross-license situation. It's a great offensive tool to protect your innovations, to keep third parties out of the market. It's a great way to attract capital if you're looking for investment. And it's a good deterrence first-to-market tool, and then also a marketing tool as well. The disadvantages to patent protection: there are the costs associated with getting the patent, the time associated with getting the patent. There's a cost to enforce all of these patent protections that I'm going to discuss. It's up to you to enforce those patents. The U.S. government's not going to do that for you. And then they all have a limited life, generally about 20 years. So we're also going to talk about trade secret protection and contract protection, which are also available. So the first patent that we're going to talk about is, oops, I missed a slide. Oh, no. So the first patent that we're going to talk about is actually not issued by the U.S. Patent Office. It's issued by the Department of Agriculture. So it's called the Plant Variety Protection Act. And it also gives you about 20 years of protection. Out of all of the patent protections that I'm going to talk about, this is the simplest and least expensive to get. The application process is very easy. You make a seed deposit, you pay the seed deposit and filing fees, which are approximately $5,000. You fill out a form that asks questions about the genealogy and the selection of the cultivar, traits, and other relevant information examination. An examination is made regarding the plant's stability, distinctiveness, uniformness. And then once all of these things are done, the examination is completed, you get that certificate that you have plant variety protection. And once you get that plant variety protection, what that means is that you are protected against others from selling or marketing or importing or exporting that protected seed. The kicker here is that part of the Plant Variety Protection Act does require a seed deposit. So this type of protection is currently only available for industrial hemp. It is not available for marijuana. So that is a limitation on this protection. Another limitation to be aware of is that there are exemptions to infringement of a plant variety protection certificate. There's non-commercial use defense. There's farmer's right to save the seed for subsequent planting. There's farmer's right to sell the protected seed for non-reproductive purposes, so biofuel, that kind of stuff. And then there's a research exemption, which allows the protected seeds to be used to develop new cultivars. So certain of those exemptions, for example, the right to save seed and the right to sell seed for non-reproductive purposes, those can be limited by contract. Just to know. Let's come back here. Now, another type of patent is called the plant patent, and this is issued by the U.S. Patent Office. The requirements are similar to a regular utility patent. It has to be new, distinct, have utility. The difference is that the description requirement is relaxed, so your requirements are basically a variety name, and then a specification including how the cultivar was made. And here with the plant patent, you're limited to only asexually reproduced plants. And then describing the botanical features of the plant, including the one that makes it distinct from other types of plants. And then there's one claim, basically saying, you know, the begonia as shown in the photos. Similar to what we discussed earlier, the term is 20 years from filing, and grants you the right to stop anyone from making, using, selling, or importing that asexually reproduced plant. So again, you're limited to asexual reproduction. There's no maintenance fee. And infringement of that plant patent occurs only when someone does that asexual reproduction. So the utility patent is the most common type of patent. It is the most complicated to acquire, costs the most to acquire, and is the most difficult to acquire. It has a more robust specification requirement. That being said, it does grant you more rights than the plant patent or the plant variety protection certificate. So, for example, you could protect the modified plant genes, proteins or products from that plant, classes of varieties with specific traits, for example, resistant to a certain mold. So you wouldn't be protecting just that plant, you'd be protecting that trait in general. So I think there's, you're probably familiar with some utility patents that overreach, and that probably will be an issue for the industry. The way that I always think of it is it's very similar to the internet when it first came out. So like, think about 1998, there were a lot of really poor patents being issued. And that kind of came to head about 5 to 7 years ago. You start hearing that term patent troll. And that's when these old patents with these hugely broad claims like shopping on the internet were being asserted against companies like Target and Amazon that had online stores. What happened there is the market corrected itself. So in this case, the law was actually changed so that those patents primarily became invalidated. And I think here, it's true we may see some patents issued that are overly broad. I think that those patents though will get invalidated either through the federal court system or through internal use review systems as well. It is unfortunate that there is this lack of what we call prior art, which is the resource that the USPTO looks to see what has been done before. That's not there really for the marijuana industry, but I do think that is exactly that. So I do think that that is coming. So you have all these options. What do you do? What do you choose? Well, these are not all mutually exclusive. You can combine your various options. It depends on the variety, the cultivar itself, and then obviously the amount of money you have to spend. So plant patents are going to be great for protecting asexually reproduced cannabis varieties that lose their phenotypes when crossed, but are not going to be effective at providing exclusivity for seed-stable plants. So if the commercial value can be derived without coding, then plant patents are probably not your best option. Plant variety protection certificates with their research and saved seed exemptions are probably less valuable if the primary commercial value is as ingredient stock. And then another limitation for both the plant variety protection certificates and for the plant patents is they just protect the plant itself. If you want to protect a broader reach than just that physical plant itself, you really are looking at the utility patent with its ability to protect a variety of traits, non-plant aspects of the invention, such as a dietary supplement. So you really are limited to utility patent to protect those aspects. Another consideration is obviously this deposit requirement. If you are ineligible to meet that deposit requirement for the USDA Plant Variety Protection Act, then that's not an option for you. So, the last two things that we're going to discuss are trade secret and contract protection. So trade secret, pretty simple. That's any confidential information that has commercial value because it's a secret. 3 requirements: secrecy, surprise, commercial value because it's a secret, and then reasonable steps to become a secret. Trade secrets are great because it's potentially can last forever. There are no costs associated with them, and they're effective immediately. You don't have to register them. The disadvantage is that they do not protect against independent development or reverse engineering, and collection of damages can be difficult, and there's no way to unring that bell once that trade secret is out. It's out. So for plants, trade secrets are going to be like in the form of the inbred lines to form the cultivar. So not the cultivar itself, but the inbred lines that are used to make the cultivar. So that would be an example of a trade secret for a plant. Contract law. A contract is any agreement between 2 or more parties. So in the seed industry, a contract, example contract would be a material transfer agreement, which outlines what kind of practices are allowed with the seed that it's attached to. Another thing that you may have seen in the industry, so again similar to the software world, is a bag tag agreement, or also referred to as seed wrap license, similar to a shrink wrap license in the software you buy. So that would outline what you are and are not able to do with the seed that you purchase. So example tag language is purchaser agrees that is granted a limited license to only produce grain for feeding or processing, resale of seed or supply of safe seed to anyone, including purchaser, is prohibited under this license. So the license is something that you get automatically upon purchasing the seed. And those are the various types of IP protection that you can have for your plant, very briefly.
In 15 minutes.
Yes.
Awesome.
And now Beth is going to talk about another important aspect of open source.
Thanks, Carla. And after I'm done, we're going to be able to ask some questions about this. So, because I'm sure that folks have many. Let me go to my slides now. There we go. I'm like totally new to this PC world thing, and it's like really like making my brain. There we go. Wait, who knows how to use a PC? I'm just going to close yours, Carla, because you're done. And make this easy. There we go. Then you. Full screen. So we're going to talk a little. So now that Carla has really outlined where licenses and like how patents and licenses work, we're going to talk a little bit about how open source fits into this schema. And this is it's a pretty important thing. So the first thing that's really important to recognize and understand. And this is part of why a lot of this is really difficult to talk about, is that, when we think IP, we think about all of these different laws, but all of these different laws actually don't really work exactly the same together. So for example, patent law is not quite the same as copyright law, is not quite the same as trademark law. And then on top of that, data ownership law does not equal the same thing as IP or plant law. And so to make things, and all of these things, when we talk about open source and what open source is, sometimes we're talking about copyright, sometimes we're talking about data, sometimes we're talking about, sometimes we're talking about a plant. And so it's important to understand that all of these laws work really differently as we think about these terms and make decisions about what we want to do with our plants, and also in some cases what we want to do with our data. But we're really going to be sticking with talking about plants for the most part right here. To that end, the way that open source software works, open source software works under copyright law primarily. Open source plants fall under sort of a mixture of laws that touch on patents, license, and different types of registration. One of the really great open source projects out there with regards to seeds and plants is the Open Source Seed Initiative and Open Source Seeds. Open Source Seeds is based out of Europe, and the Open Source Seed Initiative is based out of the US. The reason why these two different groups have two different sort of organizations is because the laws in the United States are a little bit different from how they work in places like Europe or in Canada. Canada and Europe are being a little bit more similar, and the US, similar to our whole we're going to do the inch and the foot, and we're not going to do the metric system. Similarly, our laws are just a little bit different, a little bit special. Through the sort of open source seed initiative paradigm, a company called Strainly, which is based out of Montreal, has actually created an open source license, and it's called the Open Cannabis License. The Open Cannabis License allows you to freely use your open source seed and doesn't allow for any kind of privatization or plant variety protection for derivatives of those seeds down the line. I also believe that there might be some kind of attribution clause in this license. This license is a great option. It's also one that works better with laws in Canada and the European Union, and not as well in the United States. And so for that reason, we've currently sent this license to a few lawyers in the United States for review and potential modifications so that we can have a better standard license to be used here. This system also works with a plant registration system through open source seeds. That is based in Germany, and so there is actually a system set up where you can go and you can register your plant, any plant, including a cannabis plant, and then have a license to go along with it. However, it's based in German law, and should you ever need to litigate it, you will need to go to Germany. So we are working on trying to fix that even as we close, because it's really effing important. Another sort of paradigm that someone has created, which I think is important to touch on here, is cannabis breeders' rights. Jerry Whiting, who actually created this system, is not able to be here, which is too bad, because I'd love for him to be able to talk to some of this stuff. At a high level, what he's created is this sort of matrix of different options for, what type of propagation are you using? Is this seeds or clones? Are you doing commerce with this, or is this something that you just want to sort of share with your friends? Do you want attribution? So, for example, if your plant is bred with another plant, do you want for that person to then say, oh, well, Mean Gene from Mendocino gave me this plant, and I need to make sure that I'm crediting Mean Gene whenever with whatever it is that I propagate. There are not actual licenses associated with these things, but one of the projects that we really look forward to doing, even after we close, is putting together some standard licenses to some degree based on this, but in general in a really collaborative way with growers. Basically, work with a team of growers to come up with a few different, 3 to 4 options versus 25 or something, so that we can have a common legal language to work with. I'm going to touch on this really quickly just to sort of give everybody, just again to remind people that data ownership law is not the same thing as copyright law, it's not the same thing as plant ownership law, and there's a wide data spectrum, which actually is a whole different conversation for another day. It may be something that people can come and talk to us tonight, talk about tonight at the Botanist Bar at 7. But in sum, one of the things I'll say is I want to leave people with this quote by Richard Stallman, which one of my board members used to say to me, and I was like, every time you say that, it sounds like nails on a chalkboard, but I think he's actually right, which is that there's no unified thing as intellectual property. And I think this is part of why things have been really confusing for Open Cannabis Project, and why things have been really confusing for people in general, when it comes to things like ownership law and inventorship law. And I'll just read this. There's no such thing as intellectual property, it is a mirage. The only reason people think it makes sense as a coherent category is that widespread use of the term has misled them about the laws in question. The term intellectual property is at best a catch-all to lump together disparate laws. Non-lawyers who hear one term applied to these various laws tend to assume that they are based on a common principle and function similarly. I agree. I'm still going to probably use the term intellectual property, but I want to leave you with that as we think about all this. When we talk about intellectual property, and when we talk about open source, and when we talk about patents, and we talk about licensing, we're talking about lots of different types of law. Ultimately, one of the main reasons that Open Cannabis Project is closing is that we realize that if growers and breeders are going to be able to protect their work and really stand up in this moment of cutthroat commercialization, I want to give you and make available to you all of the options that we've talked about today. There is not just one option that suits all needs. And I'm also not going to tell one group of people to fully open source their work when other people are going in a proprietary route and will crush them in the marketplace. So I leave you with this today. Let's have great conversations about law and how they can work better for you. And I will now open the floor for questions and look forward to talking about our feelings later on tonight. Thank you. If you have a question to ask, raise your hand and I'll bring the mic to you because we are recording and I want to make sure that it gets onto the video. All right, here we go.
Hello. So thank you, ladies, for such a great presentation. My question is a little bit broader, and I'm thinking of the global space as well, because cannabis is becoming a global market very quickly. And I use just one example, greenhouse seeds, which is a very well-known seed bank out of Holland. And they recently moved to the United States and South America, where I'm originally from, and a bunch of other places to test genetics. And they have been incorporated now as a new entity called Greenhouse Medical. So their whole business plan, so to speak, is to create a huge database of traits, genetic traits of certain crossbreeds or whatever, seeds and genetics, where they connect them to their cannabis profile to certain conditions, medical conditions. And we see that in practice, what that really looks like is that they'll go to places like Congo or Brazil or Colombia and test these different genetics in different environments and soils, and then want to eventually patent those traits. And when you're in these regions, the immediate response by the locals is, we are very concerned about this, but for a variety of reasons. So I'm not sure if I have a specific question for you, but I wonder if you could comment a little bit on the sort of ramifications of patent genetics and applications in the therapeutic setting.
Do you want to go first? Okay. All right, I'll tackle this one. I think that you are speaking to a really important problem, and I think that you're speaking to a really important problem that many of us at Open Cannabis Project have thought about a lot in this greater scheme of OMG, what is happening in the United States, in Canada, and around the world when it comes to cannabis. And another reason why I think it's important to, again, when we think about open source, to think about critically, is when we think about communities who have been tending to things like land races for a long period of time, and who may be targets of biopiracy and that kind of thing. There is a very real concern for that, and it's very real. One of the things that intellectual property law, or patents and license, or actually really patents, let me be clear, patents really prioritize plants that are novel and that are unique. Many of the plants that we care about the most, and the ones that we want to preserve, are old. They're old. They don't really even qualify for a patent. And so, do we want to open source those and say that they belong to everybody? Or do we want to draw a line in the sand and say, hey, this community has been tending to this plant for hundreds or thousands of years, we should be giving them royalties, they should be like main stakeholders in the future of those genetics. I'm of the latter thought. My thought is that we should be thinking about systems that really help them. And as we think about, how do we do documentation better? How do we do, how do we create better prior art, which is something that honestly I'm still interested in working on even after this project, and have some exciting conversations coming soon, hooray. This is something that we need to be thinking about, something that we need to be doing. And we also need to be looking to those communities to be in charge of their own documentation. This is not, an opportunity for the United States to be like, hello Jamaica, once again, we know what's best, that's not how it's supposed to work. It has to start from the community up, and I can't say that we have solutions, but we are getting a real clear picture of the problem right now, which is actually useful, because once you can really clearly see the problem, you can design better solutions for it. Sure. Questions?
I was just going to comment on, there's something called the Society of Ethnobiology that has a position on the protection of indigenous people's seed rights against, they call it biopiracy of indigenous rights. So it's a pretty cool movement. It's getting started, but it's getting some momentum. Definitely, I think that's what you've been talking about for a while. It's good.
In the best of worlds, the philosophy behind patent law is that you're rewarding someone's innovation. So if someone has worked and cross-bred plant lines and really spent years developing this perfect cultivar that has this perfect trait that they really worked to isolate and perfect, that's the reward they want. If the patent system doesn't want to reward old information. So it's a failure of the patent system, as I mentioned, that we don't have the database of information that the patent office can look to and say, oh, this has been here forever, we're not going to award a patent on it. So that's a failure of the system, but the philosophy behind it is we're going to reward your innovation by giving you 20 years exclusivity, and in exchange of that, you're going to disclose everything so that someone else can take that information and build up on it. So improve it even more.
And one thing that I will say is, when I started with Open Cannabis Project, I found myself immediately very critical of the patent system and critical of the USPTO. I have to say that some of their, I'm still gonna be, and I got a lot of feelings about this first inventor to file situation that has brought about the whole patent troll thing. So that's the one thing Obama did that I was one of the few things that Obama did that I was not a fan. But at the same time, it is a system that you can counter things once they've been issued. It is expensive, but I have been hopeful in seeing some of the recent rulings against some of the recent sort of broad patents in the cannabis space. One notably being a GW Pharma patent that was, claims 1 and 2 were thrown out. The patent office and the examiners do really seem to want to get it right. And also the rules are just difficult and favor rich corporations So that's like America, so here we are. Yeah. All right, who's got another question? Go ahead.
This is a tactical question around trade secrets.
Yeah.
So, in certain states, particularly if you're setting up a nursery, you have to disclose in your SOPs a lot of different processes. The question is, in that disclosure, are you putting your potential claim to a trade secret at risk?
Depends. It may be that yes, you are, it's maybe trade secret. So it depends, and maybe that yes, you are, then maybe trade secret is not the best option for you. It depends on where that disclosed information goes. So for example, sometimes when you sign up for a newsletter or you give information somewhere, they'll put limitations on where that information is going to go. So it really, unfortunately, depends. But that's a good thing to consider because you have to think down the line, am I really keeping this information secret? I did say that trade secrets have no cost associated with them. They do in a sense. I mean, you do want to, if you have that opportunity to sit down with a lawyer and get those employee confidentiality agreements down, get those independent contractor confidentiality agreements down. So you are required to keep it secret in contract law, which definitely requires a lawyer sometimes. But once those systems are set up, then it's sort of a process system.
Disclosures to certain state agencies,
Mm-hmm.
which I don't necessarily have to be made with the state of California.
Yeah. So it could be that secret is lost. It depends on where that information is going.
That's a great question.
What would you say in Oregon, there's public records exemptions for trade secrets and confidential stuff. So if you mark on your document it's trade secret, it's confidential, then in Oregon, the state agency couldn't disclose it to anyone who requested through a public records request. Do you think that's common across the state?
Universally true, and I don't know if that's universally true for each disclosure. So it may be, like, for example, when you have to disclose ingredients for like dog food, those are ingredients that you have to disclose and that are listed on the side of the bag. You can't just say, oh, this is a trade secret, don't list those on the side of the bag. So there's going to be a different situation, different truth for every disclosure. But that's a great point. Yeah.
Anyone else on patents, licensing, open source? No? All right, well, thank you